things that, I don't wanna be with Joel, okay?
Joel's a good guy.
I love Joel. All right, I don't wanna make sure that this is personal at all. I don't think, that's not what I'm suggesting by this at all. But I don't wanna be with real water where the jury says, everyone over here is liable for this.
One final comment on my prior decision. I think this is a very important place of the record. And I look at this from this perspective. What was never produced was point of sale data. No.
The RP meter?
No.
That was the last thing we heard.
I understand, but at the end of the day, point of sale data was not produced.
I don't know what the court thinks is on those spreadsheets, but.
Well, the spreadsheets were as a result of an SQL search.
Yes, sir.
Right? But that's not point of sale data.
It absolutely is, Your Honor. I'm sorry that I didn't do a better job explaining to the court, but there's a fundamental misunderstanding, I'm afraid you bear respectfully, sir.
Well, I mean, there's a fundamental misunderstanding is what's contained in the opposition. Because the opposition says this, point of sale data is contemporaneously recorded and preserved at the store level.
Yes, sir.
It is electronically sent every day to Whole Foods data warehouse system where the data is maintained in a relational database or computer server and is available for analysis and retrieval.
Yes, sir.
All you had to do was retrieve it.
That's exactly what the spreadsheet is, Your Honor. I'm sorry that court has so fundamentally misunderstood it.
Well,
that's what the data is.
Well,
it is point of sale data. That's what the sworn affidavits say.
Okay.
That's what the evidence is. That's what the argument was.
Well, the argument wasn't that. This was the argument. No, I know what the argument was. The argument was Whole Foods in-house counsel, John Hempley, requested Craig Schrank, a business intelligence engineer who works exclusively with Whole Foods, data for its indirect parent company, Amazon.com. Query the Whole Foods warehouse data system and retrieve all available data responsive to plaintiff's requests. Mr. Schenck crafted a computer language inquiry with which to query the Whole Food data warehouse, period.
Yes, sir.
The query known as SQL. We don't even know what the query was.
You do, Your Honor. And again, the SQL data was produced on 0638 and 0639, and we showed the court that during the hearing.
And we could have produced the raw.
That is the raw
point of sale
data, Your Honor. That is the raw data.
And I don't want to repeat what Mr. Parker said over and over again, but the cash transaction data has never been produced, has not been produced to this day. The in-store data has not been produced to this day.
All you had to do is produce the raw data because we don't know what.
Your Honor,
I'm just telling you, that's my decision.
I understand.
Yes.
And
Now, if you think I've gone too far with the sanctions, file a motion, I have no problem.
well, and not only that, Your Honor, but I think you just fundamentally misunderstood the facts underlying it. That is the raw data. That's what the evidence says. We respectfully, I understand the court's ruling. We'll wait for the order and move to reconsider and take other appropriate action. But this reflects a very fundamental misunderstanding of everything that was argued and put before the court.
But my point is, the raw data, and that's the reason for my decision. Let's move on to the next
14.
Your Honor, this is plaintiff's motion remain number 14 to include argument that the orb meters somehow or another measure hydrazine. Let me just show you the arguments that we think should be precluded to start this off. Chris, can I have Dr. Santamaria from the motion eliminate 10 through 6, 7, please?
Excuse me, Maria?
Dr. Santamaria, page 10, lines 6 through 7. Okay, can you blow that up a little bit? So this is what her opinion was. Again, she's a toxicologist. She's saying the orb meter does not introduce, emit, or release toxic substances in the solutions that it's used to measure. We're not contending it does. No one's ever contended that, Your Let me show you the opposition argument. This is from the reply, Chris, page 2, lines 24 through 26. This is what Hanna's arguing. In other words, had the ORC meter been used 100% correctly, it would have made no difference since an ORC meter cannot detect hydrazine or any other foreign contaminants in a liquid solution. An ORC meter can only detect electricity, it does not detect chemicals. Well, there's been no allegation made that an ORC meter can detect hydrazine. Let's find the next one, Chris. It's on page 3, lines 7 through 9. So, plaintiffs must prove causation and will be attributing hydrazine as the cause plaintiffs' acute liver failure. True so far. Defendants must be able to rebut that causation element with the fact that the MW500 meter does not test for chemicals that cause plaintiff's injuries. That doesn't rebut the causation theory, Your Honor, because the causation theory is that the ORC meter did not properly measure negative ORC, and because of that, the real water employees added too much concentrate in, increasing the amount of rocket fuel. That's the contention. The contention is not, like they're saying, that there's some hydrazine measurement being done. And here's the final one that shows the problem. Plaintiffs must prove that Hanna caused the damages suffered by plaintiffs. Plaintiffs allege that they were injured by hydrazine in real water. This is the core argument of plaintiff's case that Nazi rocket fuel hydrazine caused massive liver damage, up to including death. Defendants must be allowed to rebut the causation element. Furthermore, by not allowing defendants to state that MBF500 does not measure for chemicals nor hydrazine will be prejudicial to defendants, as that's the key link in the chain of causation. Okay, that doesn't have anything to do with the chain of causation, because we are not contending that this meter was intended to, did, or even could measure for hydrazine. It was an ORC meter that was intended to measure the negative ORC when they're making alkaline water. So we're saying it wasn't fit for that purpose because it needed to be oxidized. They didn't tell anybody, but we're not saying that the meter was measuring hydrazine. So the problem we have here is the defendant is arguing a point, and they're even calling it the key link, a point as a defense that is not really a defense because it doesn't relate to any of the claims. So that's why we think that this type of argument should be precluded. I don't have any problem with them saying that their ORC meter was fantastic at measuring negative ORC, or that real water was using it perhaps improperly, or that there's no proof on a particular day that there was a negative ORC reading that was inappropriate. I have no problem with any of those defenses, Your Honor. But I do have them a problem with them setting up a straw man and having an expert witness come to the jury and say, oh, this ORC meter doesn't measure hydrazine, so we're out of the case. Okay? They're not out of the case if the ORC meter can't measure hydrazine. So that's the type of argument and defense that this motion is intended to preclude. And for that reason, we think the motion should be granted.
Okay. Sir.
Thank you, Your Honor. I think the court is starting to see what I've been trying to figure out in this whole case from the very beginning is what exactly is it that my client's instrument did wrong. Today you heard from Mr. Kemp that we don't have any problem telling the jury that your instrument read negative ORP fantastically. I think is the words he used.
I said I don't have any problem with you telling them that.
Agreed.
Yes.
Agreed. Me saying that.
I agree.
And that he doesn't have any problem stating that someone from Real Water didn't use it correctly. Superseding intervening cause of action. What he wants us to not be able to say is, I think he's going to allow us to say that this is what it does. And I have talked to Mr. Kemp about this, and he said, yeah, if you wanna tell the jury that it reads electricity in millivolts in liquid solutions, I have to be allowed to say that. What he wants us to not be able to say, which he wants the court to say, is that you can't say that it doesn't read chemicals. Well, it's hard to not say one without the other. If I have to talk about electricity that it does read, it excludes everything else. It only does one thing. Therefore, it can't do anything else. Now, what's gonna happen in this case? You're going to be told, the jury's gonna be told hydrogen.
No, I kinda get that, but, and tell me, does this make a difference? Because you look at the motion in limine, and it seeks to preclude defendants from arguing or inferring that it is a defense that the orb meter does not cause or measure hydrazine. That's kind of a different issue.
Okay, tell me how.
Well, I think, it's my recollection, part of their theory dealt with the instructions and packaging that accompanied these orb meters, and the fact that potentially your client knew what the purpose the orb meters were being used at the real water.
None of that evidence has been before you yet, Your Honor.
But I mean, that's kind of what I understand what their theory is.
It could be a theory, but it would be wrong with regard to Hanna Instruments, since we didn't have anything to do with the labeling, packaging, and instructions.
Right.
Since it came to us in plastic, never opened by us, all of the instructions, all of the labeling was done by others, not our company, passed on to Milwaukee, then Milwaukee sold it to Real Water. Now, the next thing is, we don't even know what Real Water is using it for. We have no idea. We don't even know, Hanna doesn't know that Real Water makes bottled water.
But doesn't their theory of liability, as your client is concerned, focus on the label?
It could be for Milwaukee, but no, I don't think the labeling is where they're after it. And even if they are, there will be ample evidence to show that Real Water had all the things they needed in order to make sure that it worked properly, and that for all the years that they did, nothing ever was said that it was wrong. In fact, the time that they think that they doubled it, here's what happened with the exchange. There's a worker by the name of Casey Aiken. We took his deposition. And this is what he said with regard to this. These are the questions, and I'm obviously summarizing, but I can go to the deposition and I have provided that to the court. It is there, okay? Mr. Aiken, what happened in and around, and Ms. Neale was actually asking these questions as well. What happened with regard to this time in and around September of, it was actually September 30th of 2020. I put the ORP probe in a 5-gallon jug of water at the Henderson plant. Okay, what happened? I got a reading of -130. That means that in millivolts, it was down into the negative range, which means it's alkaline in nature, -130. Real Water had a standard, not our standard, which is part of this whole thing. Not our standard. Whether or not we meet their standard is what I'm also going to be hit with. It's their standard. What did your standard want to be? -225 to -300. Okay, what happened then? I called Blaine Jones, the son of the owner, Brent Jones, who owned Real Water. And I think at this time he calls himself a VP that was involved in the accounting area of the company, Real Water. Okay, so he calls him, hey boss, I just put the probe into this 5-gallon jug. The measurement, not test, okay? The measurement came back -130. Blaine Jones says, not us, not our standards, not our instructions, not our labeling. Add more concentrate, not our concentrate. Not our design for the concentrate. Not our ingredients, hey, this is what you should put into this. We're not into the bottled watering company at all. This just happens to be one. Most of our RP meters are used to go out into the field and test ponds, fish ponds, things like that. They're used by the National Forestry, okay? And so he says, add more concentrate. Now, the mistake that's made is that another witness, former, says, well, and Mr. Jones testifies, what I thought he would do was add maybe another cupful of concentrate, or 2 cups, and retest, 3 cups. Instead, Mr. Aiken, who's been on the job doing this stuff for a matter of a week, takes a whole other 2.5 gallons of the concentrate, okay, and puts it into the tank, thus doubling it. That has nothing to do with me, and we don't know what the concentrate is even made of because we can't read that. What Mr. Kemp wants by this motion is to say you can't even bring that up.
Well, I don't know if it's going that far, maybe it is, we'll hear from him, but I was just looking at the call of the question. And it appeared to me, they're arguing that, you know what, this can't be a defense.
What is the defense then? If you're going to see hydrazine is the problem, I should be able to respond to the jury, we can't even tell you that the problem exists. Our instrument can't do that. Thus, if you're going to say, these people got hurt by hydrazine, and I can't defend that by saying, we have nothing to do with hydrazine, that's pretty limiting. That's pretty severe sanction or pretty severe motion to eliminate. If you were in the defendant in this and saying, okay, so hydrazine caused the problems. We've heard that already. Hydrazine caused the problems. Okay. I'm assuming then they're in this courtroom with real water, they're in this courtroom with UNFW, they're in the courtroom with Real Water of Tennessee. We're all here. And we can't say what? That we had nothing to do with the hydrazine? We can say that's a fantastic reader of that, but of millivolts. But what they're saying is that somehow it was inaccurate on this particular day that Casey Aiken, who's been on the job for a week, who's not a chemist, is going to get up there and say, oh no, that reading that Casey took had to have been inaccurate. As opposed to what Blaine Jones and Casey Aiken together thought, which is, and this is a very important point, they didn't blame the meter. They believed the meter was accurate because their solution was add more concentrate.
But tell me, what is their theory of liability as it relates to warnings, warning labels in this case?
So what they've got.
I mean, ultimately, that's what.
Right, so what they're suggesting, and I think they're off on the sciences as well, let me explain. The probe, okay, let me grab it, make it a lot easier.
I actually know what, I have a good idea as to what it looks like, but go ahead.
No, that's gonna take, you're right, Your Honor. This is the probe. Do you have a picture of the photographs? You have some photographs, right?
Yeah.
Yeah, that's a good one. Let's go to the next one. Yeah, that'll. Can you blow that, just that middle part up again? Doesn't get to me where I want to be. I need one with the meter on it like this. Remember, this is the probe. Inside of this tube, and I'll be taking it out for the jury, there's going to be a very small, about 10 centimeters long, platinum tip.
No, go ahead.
Okay, I didn't know what she needed.
She was just pulling something up for me.
Okay. Inside of this is there's a platinum tip. It's about 10 centimeters in length.
Go ahead, sir. I'm just.
So here it's going to be, in this photo, you see the blue cap that's underneath here? There's a blue cap that's buried, yep.
I see it.
That, inside of that, there's a platinum tip. Okay? And what they're claiming is that the instructions on how to oxidize that for speedier readings in measurement was inaccurately instructed to potential customers. That's their thought. And that because it wasn't done speedily somehow, that caused issues, or that caused accuracy issues. The problem is, the oxidation of the probe has nothing to do with the accuracy. Accuracy is already on the warning label. And that comes from surface damage, bad temperatures, and bad chemicals. And we happen to have all three of those things in evidence in this case that have been testified to by various witnesses already. So, Your Honor, I understand where Mr. Kemp would like this to go, but I think it's very unfair for us to be here with everyone talking about hydrogen the entire time, and I'm not able to say, my probe doesn't have anything to do with hydrazine. It certainly lets the juries then say, well, then why are you here? Yeah, that's a good question. I would be asking that as well. So then he has to explain, what does the speed of reading have to do with this? If it's not accuracy that has to do with anything with oxidation of the probe. All that really is whether or not we can get certain minerals off of that before it's actually used. The reality is, we have, and it'll be the subject of another motion, that we weren't doing the testing on that, and the difference of it is seconds as opposed to days. So it really had no effect on what went on here, or the reality of things. But to hamstring us at this point in a case that has to deal precisely with hydrazine, and to use the toxicologist that's going to say, we have nothing to do with hydrazine, and we agree with Mr. Kemp, we had nothing to do with hydrazine, but then to say that somehow we doubled the amount of hydrazine because of a reading that was relied upon, but they don't have someone that's going to be able to say, some sort of a mechanical engineer, chemist, scientist of some sort that's used ORP meters to say whether or not oxidation has anything to do with the accuracy of the probe is way too prejudicial. I just don't think we should be going in this direction and trying to limit the defense.
Now, here's my question as far as, wouldn't the seventh cause of action regarding failure to warn also include your client?
No, because we didn't have anything to do with putting the warnings on there.
But you sold the product.
We did, and we put the warnings out, and you want to see the warning?
No, that's.
We've got the warnings.
But I mean, that's up to an expert to determine whether.
Yeah, and we have a chemist.
Yeah.
They have an expert, I think his name is Dr. Motley, who will testify.
Is he like a human factors thing?
No, he's a retired
Oh,
communications
they're kind of like the same thing.
professor.
Yeah, they do that also. But here's my question, and I understand your position, but like the eighth cause of action, I'm looking at it here, and I thought it was this, and this is as regards to, failure to warn. It's really and truly what it's focusing on is a package insert that went along with the product, and is inadequate for the purposes of, I guess, and we'll hear from the experts, we'll dig deeper in that, but I understand what the theory is as it pertains to your client, the failure to warn.
Right, so the tip card, the insert that goes into that, by the way, talks about machines. There's no machine there at Real Water. The machines that is described for the tip card has to do with the Kangen water machines that we talked about earlier. So again, they're misconstruing something.
And I'm listening at the eighth cause of action. It says the MW 500 ORP meter is unreasonably dangerous product because consumers would not expect. And this goes back to the consumer expectation.
Okay.
But it says, one, that the MW 500 ORP meter would not give accurate readings when used for negative ORP measurements. And I remember there was a discussion a couple weeks ago on that. Or that the MW 500 would not give accurate readings when used for negative ORP measurements unless rigorously cleaned every 30 days.
Right, and that one is I believe, been taken out by the plaintiffs. I don't think they're talking about cleaning it.
But my point is this, at the end of the day, they're focusing on the warnings or inadequacy of the warnings as far as usage of the product. That's what I understand the theory is.
Right, so that would be, who's the consumer? It's not the people that got hurt, right?
Well, I guess ultimately, I guess Bill Water was using the product.
Right.
And they weren't properly warned.
Well, they used
I'm
it.
not saying that's true. Understand that, that's the
Fair
allegation.
enough, right,
Yeah,
because
I'm
there's
not
a video of them actually showing how to do all this. And that'll be in evidence as well, and showing that they know exactly what they're doing with all this stuff. So I appreciate that, we'll have to put on that evidence and do that, but to take away this opportunity for us to be, the last thing I'm gonna do is have the jury in any way that I'm not able to say something, and the jury comes back and some jury attorney says, oh yeah, we think they're all related to the hydrazine. But we really have to be careful, because I have to be able to say we're not related to hydrazine, because the comeback is going to be, your failure to warn led real water to double the amount of concentrate that went into a tank of water. And there's science that just says that's just not correct. And we'll get into that when we put on our case, but to not allow us to be able to put on the defense, I think opens us up to quite a bit of
Yeah,
problems.
but I don't think they're trying to stop you from putting on a defense. I think.
That's what the motion is.
No, that's your motion. right?
No, this is their motion.
Okay, but I mean, there's a difference between putting up a defense and saying, look, we disagree. We've had an expert come in, they've looked at the packaging, and we think the packaging is sufficient from a warning perspective,
Okay.
right? You can do that.
So what they're trying to say is you can't say anything more about hydrazine.
I don't think they went that far.
I
I mean, unless I'm missing something.
that's what it literally says in their motion. You cannot argue this.
No, it says is a defense.
Yeah, I can't say that the defense to this is we don't touch hydrazine. We can't find it. We can't read it. We can't say anything about it. We can't tell you if it's in the product or out of the product.
Well, but I mean, if that's the capabilities of the
It's not.
meter,
It's
you
not.
can't measure that, that would just be a fact, you can't measure hydrogen.
And what they want to say is you can't say that. You can't use that as a defense.
I think there's a difference between saying that
Okay?
and using it as a defense. Because I mean, unless I'm missing something, your product is focusing on the adequacy of the warnings.
So that's what they're prosecuting. One of the defenses is, okay, let's make sure I'm not with all these other people in the same place saying I have something to do with hydrazine. And you're saying, I can't say that. You can't
I
say.
didn't say that, I mean, you could talk about what the product can and can't do.
Well, that's what they're saying. That's what they're saying I can't do. Your Honor, if you grab this motion, they're saying you can't say that. You can't say as a defense, we don't have anything to do with hydrazine. That's the motion. If you grant that motion, I can't talk about hydrazine.
But here's my question, how is that a defense to an inadequate product warning?
I'm not saying it is or isn't. What I'm saying is if this bleeds over to the jury, why didn't he ever talk about the fact that their instrument reads hydrazine?
Well, here's my question for you. What is the defense to their allegation set forth in the 8th cause of action in the complaint when they make an allegation that the 500 ORP meter is unreasonably dangerous because consumers would not expect that MW 500 ORP meter would not give accurate readings when used for the negative ORP measurements, or that the MW500 would not give accurate readings when used for negative ORP measurements unless rigorously cleaned every 30 days.
Right. So as to number one, we will have experts and testimony with regard to that that says it was completely accurate. It does not give inaccurate readings based upon what they were, that was calibration. Calibration of this instrument has nothing to do with, it has everything to do with whether or not it's accurate, and it's not a cause of action here for which they are now after. The second one has to do with cleaning. Cleaning is no longer on the table for the plaintiffs as we've gone through this case and gone through discovery. So what they're down to is cleaning is out calibration is out. The next one is the oxidation of, how to be oxidized, which is conditioning. So what they're saying is, when you're talking about conditioning of that little probe that I just talked about and tried to show you, that's what they're down to. And on that one, we will have plenty of argument to show why that is nothing, because you don't even have to do that, condition it, in order for you to get a negative reading with an ORP meter. In fact, there's another motion on that very issue that the plaintiffs have filed, trying to get my chemist who did the testing on this conditioning question and have that thrown out as well. Okay? So, Your Honor, I appreciate all of this, but with everything that I've got to do, the last thing I need is not to be able to say one thing and leave in the jury the possibility that when hydrogen is going to be talked about with all the other defendants that I'm going to be sitting at the table with, that somehow someone says, when it comes to hydrogen, oh yeah, I think they're a problem with that as well. That goes way too far into not being able to say that. It doesn't have to be said a million times. I can say, just so you understand, when it comes to hydrazine, I'm not related to that particular cause of action. I have nothing to do with reading whether or not hydrazine is in the solution. I should be able to say that. That is a defense to causes of actions 1 through 6, right?
But I'm looking at their argument. It says plaintiff's theory is the work meter did not properly measure negative work.
And in fact, it did.
Yeah, well, I'm just saying that's their theory.
Right, I know.
Yeah,
they can be wrong all day long, Jim.
right.
I get that.
Yeah, and not that the work meter was supposed to measure hydrogen, or it admitted hydrogen.
Right, it doesn't.
They agree with that.
And all I want to do is be able to say that to the jury, and they don't want me to be able to say that. I don't know why.
I don't think they said that.
That's exactly what they just said to you.
Okay, we'll find out.
All right, let's see here then.
Let's hear it. Let's hear Mr. Jones.
Your Honor, the failure to warn theory, as is the court indicated, they did not provide proper warning or instruction as to how to condition the probe. You need 4 to 5 days in vinegar to condition this probe. Real Water thought they were supposed to do it in 5 minutes. And we say that because Mr. Bush testified to that. He's the production manager. Mr. Blaine Jones did a YouTube video. Do we have that, Chris? Maybe we have it, maybe we don't. But in the YouTube video, which is the video that Mr. Rasmussen just referenced, there's a box there where he says condition the probe for 5 minutes in vinegar, not 4 to 5 days. So these people all thought, like pretty much every other person who bought this, that you should stick it in vinegar for at most 5 minutes. So our contention is that the distributor, Hanna, I guess the distributor is technically Milwaukee.
Word it in.
That's not.
Okay.
Can we play it well?
Yeah, can you give me the little box in the top left there? I think we found this is the right video.
Agreed.
Word it in
So there's the orb meter on the left. And you can see
to the solution.
See how it's going down to negative.
And you can see that color change and that negative charge in the probe or the meter.
Yeah, it's going well over negative 130.
And that right there is a powerful demonstration for why
That
we're
was the one
testing
that has the.
regular bottle of
I've
water.
seen these before. But
Right, you've seen these before in connection with motion for summary judgment 1. But there's a portion of this video where in the top left portion of the screen, they have some sort of card there that says, when you condition the probe, put it in vinegar for 5 minutes. So the point is, they thought it was 5 minutes. They didn't think it was 4 to 5 days. And so Milwaukee sold it to Real Water. Hanna sold it to Milwaukee. One of the Hanna entities in Europe, I don't know which one, on the top of my head, probably Hanna SRL sold it to Hanna USA. But even if Milwaukee and Hanna are both distributors and not manufacturers in this chain, they're liable for a defective warning. Whether
No, I
they
get that.
well, yeah, well, they seem to think that if they didn't draft it, they're not liable.
Well, it would be like we didn't design it or we didn't manufacture it. You're still liable for the distribution.
You're liable for the defective warning. Now, what are the consequences of this defective warning? The consequence, and this was Jason Brown's testimony, I showed it to your honor. He said that if you don't condition it properly, then it will take, quote, hours or days, unquote, to measure negative ore. Hours or days. That's their general manager. Mr. Rasmussen says it'll still reach a negative reading. Well, yeah, but it'll take hours or days, and that's not a reasonable amount of time to expect these people who are used to ORP readings for positive and negative to come out in a matter of 10 to 12 seconds. It's not reasonable to expect them to stare at this for hours or days, especially if you provide no instruction whatsoever. So here's what happened. Mr. Rasmussen alluded to it. When Akins did was making what we call the super bad batch, he put the ORP meter in and it capped out at negative 130. That was his testimony. But you just saw from Mr. Jones's demonstration, he was already up to negative 185. And the testing their experts done, which we think should be excluded, even that testing shows that if you don't oxidize this, it caps out at 130. So this is like a thermometer, Your Honor. Imagine a mother is using a thermometer to see whether or not her child has a fever, is sick or not. So she sticks the thermometer in the child's mouth after putting her hand on the brow and seems to be hot. So she sticks the thermometer in, and that thermometer always caps out at 98.6 instead of the 101 or 102, that's the real temperature, because that's where it caps out. That's the problem with this product. If you don't oxidize it properly, it caps out, and then, in Mr. Brown's testimony, it takes hours or days to measure. Now, Mr. Rasmussen described Mr. Akins' testimony, and he said he's on the job for a week. I don't have any problem in pointing that out to the jury. Says he put in an extra 2.5 gallons, which maybe he should have put in more in a cup. I don't have any problem in saying that either, Your Honor. But my problem is if he tries to defend a failure to warn case by saying that, oh, ladies and gentlemen of the jury, you have to find for the defense if the ORP meter doesn't measure hydrogen. That is not a defense in this case. And let me have his key link back up, Chris. It was the reply 3:19 through 22. Yeah, they want to state that it doesn't measure for chemicals or hydrazine, and that's the key link in the chain of causation. That doesn't have anything to do with the chain of causation in this case, because the chain of causation of this case is whether or not there was additional concentrate put in, as Mr. Akins admitted he did. That's the chain of causation, and whether that relates back to the failure to warn. Okay, the chain of causation has nothing to do with whether or not the meter measures hydrazine or not. So this is what we object to. We object to them making up some defense, standing in front of the jury and saying, you got to vote for my client not liable because the meter doesn't measure hydrazine. That's what they want to do. And so that's what we think should be precluded, Your Honor. And I think it's really
The
ironic.
question is this, how is that even relevant? I mean, because it really comes down to, I mean, I understand the case. Because number one, you can have defective products based upon the warning. You can have manufacturing defects, right? We can have design defects. And so I understand your client didn't manufacture the warning. I get that, but they're stuck, right? It's a defective product.
Look, you're on distributed products, that's part of the problem we have here, right? I'm gonna go in trial with 2 different products. One product is right here with real water, fair enough?
Right,
One product is right here and it's this ORP meter, correct?
right, but my point is
My
this.
point is, I don't wanna be over here ever. So, one of the things that, I don't wanna be with Joel, okay?
Joel's a good guy.
I love Joel, all right, I don't wanna make sure that this is personal at all, I don't think, that's not what I'm suggesting by this at all. But I don't wanna be with real water where the jury says, everyone over here is liable for this. When there are obviously 2 causation packages going on here, fair enough? One has to do with failure to warn.
We're getting back to your client, failure to warn, right?
Right.
And the inadequacy of the warning, that's a.
And we'll defend that, and we've got plenty of great defenses for that. But what I don't need to also do is come back and be, oh, by the way, hydrazine. Oh, I wonder if that probe had anything to do with it. I need to be able to crystal clearly tell the jury we have nothing to do with it. It's not a defense, but we had nothing to do with this.
Okay. Well, here's the point, and I don't know if you can say we had nothing to do to it, because if that's the case, there would be no claim for a defective product based upon inadequacy of warning.
Oh, there would be, Your Honor. This has nothing to do with whether or not that. You will finally get to the evidence at some point. Someone will finally get the science of what's going on here. My product had nothing to do with what happened here.
But understand, I'm not making that determination, I'm just talking about what's being.
You've already made the determination that I need. You just don't realize that you said the unintended consequence of this manufacturing process was this happened. You've already made that.
It was
point.
never intended, was it?
Oh, and that's the point. We can't see that. It's nice to tell us that the child gets sick from a fever and say that that's never the unintended consequence of the thermometer.
Remember this, in strict products liability, intent's never an issue. It's always the focus on the property and on the product, and whatever is a defective product and reasonably dangerous. That's the whole thrust.
I
And
agree.
it can come three ways: warning, it can come manufacturing,
Mhm.
and it can come
And
in
they're not here.
design.
Right.
Right, and that's kind of my point. And but here's the thing: I don't think he's saying you can't talk about what the product does and doesn't do. But there's a
Okay. difference
difference between doing that and saying, look, ladies and gentlemen of the jury, you can't find in favor of the plaintiff against my client because this product doesn't measure hydrazine.
I can say that.
No, that's what you want to say.
I do want to say that. I should be able to say that.
Yeah, but
This
that,
should not be.
yeah,
Wow.
but see, that's not a defense.
Your Honor,
That's not a defense.
I'm making sure that the jury is not confused that I have anything to do with hydrazine. I should be able to say
But
I've
that's
done.
not, but that's not what you're doing. You're not saying, look, ladies and gentlemen, this is what my product can do and can't do,
Okay?
right? You're
Right.
not saying that, that's different than saying, look, you have to rule in my favor.
Okay,
because
I haven't said that. I've never used those words yet, have I?
Yeah, but that's a defense.
I agree. Because it is a defense to theirs. If he has cross claims against me, that's a defense. Isn't it? If Joel has a cross claim against me, or UNFW has a cross claim against me, that's my defense, is it not?
Well, I think your defense would focus on the adequacy of the warnings. That's kind of what it is, right? Unless I'm missing something here. And so, I'm not saying you can't stand up in front of the jury based upon, I don't know what your expert's gonna say, and attack the adequacy of the warnings head on. You can do that.
And we will be.
And just as important, I'm not saying you can't talk about what your product does and doesn't do as
Thank
far
you.
as negative and positive orbs or whatever that stuff is. I know you know it real well. But my point is this, you can't say just because it doesn't manufacture or produce or was designed to produce hydrazine, ladies and gentlemen, you gotta rule in our favor. Because that's not really what the claim
I
is.
see your point, Your Honor, and that's where I think there's a difference between being able to instruct the jury on what it can and can't do, and what the defense is to the questions of, was this adequate labeling or warnings? That part, I get the difference. I'm worried about the overbroad nature of what this is. There will be jury instructions that say, so-and-so, 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 and so-and-so should be liable based on theories of strict product liability because hydrazine was in the product that the consumers consumed. I should never be on that list.
All right, I understand your position. I do.
Okay.
Just rounding up, this is why we filed a motion for summary judgment, that one of the intended uses was to measure negative orb when making alkaline water, that the court granted to prevent this kind of problem. And that's what the jury will hear. They won't hear that one of the intended uses was to measure hydrazine. We're not gonna argue that, because that's not our case. And it shouldn't be a defense to a claim that's not being made. So that's why the motion should be granted.
Okay. Mr. Rasmussen, I'm gonna be real clear on this. I'm not saying you can't have an expert or someone discuss from the company what the product does, what it was designed to do. I'm not saying you can't do any of that. But remember, the claim after looking at the claim for relief of eighth cause of action, is for strict products liability based upon inadequacy of warning. So you can defend it in warning all day, but I don't think it's a defense to say in front of the jury that this product, I mean, your client's product doesn't create hydrazine, or however you'd want to say it, and use that as a defense. You can talk about what the product does. It wasn't what the purposes were and all those things. But at the end of the day, you're gonna have to defend this case based upon the adequacy of the warnings.
Thank you. You know, what I'll expect then is that the jury instructions at the end, that there's gonna have to be different ones.
Oh, absolutely.
So every cause of action, 1 through 6, I'm not even gonna be at the bottom of that list for computation of damages. Can't be,
Well, I would anticipate.
since I'm not even named for those.
Yeah, I would anticipate, I don't know for sure, you're well down the road, but I would anticipate there would be a specific instruction that potentially relates to your client as the law pertaining to strict products liability and inadequacy of warning. That's what I
Right, so I've got 7 over, but the other ones, hydrazine I may or may not have heard that has nothing to do with me.
No, I understand what you're saying, I do.
Yeah, so for the record, that's Randall.
Oh, granted with the limitations we set forth on the.
Your Honor, I think the next one is 17, which is to, plaintiff's motion May 17, to preclude the meter defendants from arguing that the lack of warnings, their lack of warnings is excused by warnings on other products. You think I wouldn't have to argue this, but I do. So Allison versus Merck, let's start with that, Chris. This is our seminal case, page 4, lines 1 through 14. So 1 through 4. Okay. So this is the case where the government came out with, I think this was the swine flu vaccine, I'm not positive. And so anyway, there was a suit, and this product was distributed by the Clark County Health District. And Merck argued that, hey, since we contracted with the government, it's not our fault, it's the government's fault. And the court held that Merck was responsible for warning for its own product. Next one, please, which is 4, 7 through 9. So this is the primary rule from Allison that we cite all the time, which is that a manufacturer, including a distributor, cannot delegate its duty to provide warnings to other people. In this case, the Merck, the product manufacturer, is trying to delegate it to the health district, saying, oh, the health district should have done this, that, or the other thing. Can't do that, Your Honor. It's your product, it's your warning. Okay. Now, here's their argument. Okay, this is their argument. Let's have 2, 25 through 26. So they argue that they don't have to give warnings on their product because Allison versus Merck was ruled on before the evolution of the internet and the ability for most anyone, including real water employees, with a smartphone to watch instructional videos while opening a new device. So they're arguing that their failure to provide a warning on the key point is excused because, in theory, someone could get on the internet and find some other instruction from some other manufacturer, and you know this is so far afield from Allison versus Merck because at least they were pointing to a specific entity, the Clark County Health District. This is just an argument that we never have to provide a warning because people can surf the internet. And that is not the law, Your Honor. Let's go to the Chiavani case. This is Chiavani, which is Mr. Christiansen's nice case. It came down a couple of years, I think it was last year. Strict liability may be imposed even though the product is faultlessly made if it was unreasonably dangerous to place the product in the hands of the user without suitable and adequate warnings. So the test here is not what you can theoretically find on the internet, or something that perhaps another orc meter manufacturer puts forth. The test is what is in the package insert, the materials that you've provided, that you've put in the hands of the user, that's a suitable and adequate warning. So that's why we filed this motion. I mean, we were concerned a little bit before, but then we got this response that claims they can surf the internet and who knows what they can come up with. But the failure to warn analysis should be limited on the packaging in this case, the communications between the manufacturer, and by manufacturer I'm talking about Milwaukee, the communications between Milwaukee and Real Water in this case. It shouldn't be some theoretical, you can find something on the internet, or theoretical, some other orc meter manufacturer provides this kind of warning, you should have known that.
I mean, we can't go there, because what happens if the one you think they should rely upon is inaccurate or unreliable?
Right, Your Honor, I
Well,
mean,
then the
don't-
position would be, oh, we're not responsible for that, we didn't produce that, we didn't issue that in a package insert.
Right, that's the whole reason that the manufacturer and distributor have the responsibility. It's their product. They're the ones that are supposedly fielding customer complaints on this product. They're the ones that designed this product. They're the ones that have the best knowledge as to how this product was worked. So they're the ones that should provide information about it, not some third party on the internet. And so for that reason, I think this should be granted. Other than the internet search, they haven't come up with any specific thing they want to do. But yeah, we're concerned, Your Honor, but, so that's why we think this should be granted.
Our instructions inside of the packaging that's actually given to the consumer, in this case, Real Water, not the people that got injured, okay, has two different websites that you can go to in order to get further instruction if you would like some. Having said that, right here on the package is the warnings, right on the package. Warning. The enclosed product is intended for use by persons knowledgeable in safe laboratory practices. That was breached by Real Water. Okay? No one at Real Water had any idea about safe laboratory practices because none of them were qualified to ever work in a laboratory.
I understand, I do.
Okay, so if I warn someone not to do something and they do it, now I'm still liable for not following the warnings that I give them?
Well, the issue, well, no, that's a different analysis. The issue is whether the warnings are adequate.
So I don't know how to be more adequate than say, intended for use by persons knowledgeable in safe laboratory practices.
Well, all I can say in this regard is I'm not an expert
Sure.
in warnings or.
And then we'll get to that communications guy.
Right, yeah,
Okay.
I'm not that guy, and so, and ultimately, that's a fact pattern,
Agreed.
but, I mean, a factual issue, but, you know.
We're not using some other product. Here's the warning on the product itself. I think I should be able to say that.
If you have your, I mean, here's my point. If you have, I assume you have an expert, I don't know
Yep.
exactly what they are as far as product safety and
Yep.
what would be appropriate. Sometimes human factors and things like that get involved, psychologists. But my point is this, that's the case.
Yeah.
And here's the thing, and I don't mind saying this, I know we don't really understand sometimes, but not everybody has internet access.
Yeah, they did though, but and remember, I'm only having to deal with here because my product obviously never went to consumers. So what did Real Water have access to? And what could they have done is also part of whether or not they followed the warnings. Remember, we have a video of them showing us how to use the product, so they had a pretty good idea of how to do it.
Well, I understand there's maybe product misuse issues, I mean, I get that.
Yeah.
But I'm just dealing with the adequacy.
So once you have misuse, it's also defense to what we've got here. And that's obviously one of our defenses in this case, is that you're holding us liable for something that was misused.
Well, I don't think that impacts the end consumer would be, well, I mean, the individuals unfortunately purchase the product, that's not a defense to them because they got a defective product and reasonably dangerous. Maybe that might impact your contribution or indemnity or whatever with someone else, but we're talking about the end user, the consumer, the ultimate consumer. But here's my
Well, we'll
point.
see.
When I look at this though, tell me if you agree or disagree.
Okay?
You can't, I don't think you incorporate what it says, www Milwaukee or whatever I can see there. I don't-
MilwaukeeInstruments.com.
Yeah, I mean, at the end of the day, I don't know what your package inserts are.
That's what it says, yeah.
I don't know what's there, and those are additional warnings.
For detailed information, go to MilwaukeeInstruments.com,
Right.
okay?
Yeah.
I don't know what else to, we put in, we have all these instructions, front and back. We have a date as to when this one was done. This is March of 21 when this was revised, okay? We have warnings on the side. We have labeling all over. We have another warning that says failure can result from surface damage, improper pressure or temperature, or use with improper chemicals, all of which were violated by real water. At least that's what our evidence is going to show. Information concerning limitations of Milwaukee Instruments products can be obtained from Milwaukee Electronics Kit. We also tell them, hey, here's our limitations, and we have the website to tell you where to go to see those, and where to go to find Milwaukee Electronics Kit. And the consumer in this case, not the people that drank real water had access to the internet. They can look up any one of these things. What's in the electronics kit? And we should be able to put on all of that evidence, including what's on the website.
But I don't think any case law stands for that proposition.
Yeah.
And here's my point, when you really think about it, sometimes you're using a product and you might have internet, but you might not have access to the internet when it comes time to use the product, right? And so you open it up and you look at the warnings and then you proceed. And maybe the warnings are adequate, maybe they're not. But I don't mind saying this, I'm not gonna create new case law that incorporates the www, whatever that is there, as part of the warning. I'm not gonna do that, because I don't think that'll stand. I think it really, and it makes perfect sense, because not everybody has access to the internet. I mean, for example, you could be at the side of the road trying to fix a flat, you don't have your phone with you, and there might be something regarding the instant flat and how you use it, and so on and so on. And if you have maybe if the warnings are inadequate, you do it and it blows up. I don't know. I'm just saying what can happen. Yeah.
But you're talking as a consumer here, not a business, not a corporation that's putting out millions of bottles of water and using this meter every time to do so in some form or fashion. And if they're not, as they didn't, it appears, doing what is reasonable for a corporate retailer to use an instrument like this, then that case law is going to be made, and it has to be made here, it has to be made. The level of what a corporation has to do, as opposed to you, as the consumer on the side of the road, are two different places completely. This is not the Allison case. Now, Allison stood for the proposition that I can't take a different product and say, read this over here on this other product, and let's bring it into this case. I agree, Mr. Kemp, can't do that. That's the case law. But what you can say is, hey, sophisticated business owner who's putting a product out there into the market, if you're going to use and rely on this meter, you better read the warnings, you better read the instructions, and you had better go to the website when it tells you, if you need details for this, this is what you need to do. That's not unreasonable for a corporation to do.
I understand. I do.
Thank you.
Judge, I think the basic problem here is they use the same user manual for 35 years.
Wrong. Can't be. I just told you it was done in March of 2021. It's revised almost every year. It started 35 years ago. It's revised every year. It's not revised in Romania because they speak Romanian there. But look at, that's another motion.
Gentlemen,
Ridiculous.
I get that. Here's
You
my
want me to
point.
put Mr. Petrie's, I'll put his testimony.
Yeah, but here's
Mr.
my
Petrie
point.
said there's cosmetic changes made to it.
When it comes to the warning issue, and I don't know what claims, for example, there might be as far as some of the defendants, but I look at it from this perspective, I'm not gonna require a corporate defendant or a corporate individual to go to a website, right? And when I look at the warnings, it's gonna be based upon the adequacy of the warnings in the container box and also the inserts. And I'm not gonna place on corporate defendants any extra obligation.
Okay, I understand.
That's all I'm saying.
That's fine. We may have to move that up to somewhere else and see whether or not they'll agree with you, because I think that's an area of law right now across the country that's being looked at.
Oh, it is, it probably is. But I look at it from this perspective, not everyone, when you need products, yeah, maybe 80%, 90% of the time you might have internet access, but maybe certain times you don't have it. Even major businesses might not have access, I mean, when they have their service trucks out doing things. I mean, there's so much there. And to me, it's fairly straightforward and simple. You got a product, you got your packaging, you got your inserts. And we can all agree that one thing about packaging and inserts, over time, they can be readily changed. They can be added to, and so on and so on. And from a products liability perspective, as it pertains to the inserts and adequacy of warnings, that's a fairly easy, potentially, task to accomplish, because you can just change your inserts. That's all I'm saying.
And we did, time and time again, every
And I'm
year.
not saying that, remember, I'm not saying that it's a defective product and reasonably dangerous. That's gonna be up to the jury, potentially, based upon the adequacy
Right,
of warnings.
and look, the way that my generation, your generation, we're in the same generation, I think.
Right.
And the way, whether we get onto the internet and look up something, that's different than what they do today. If I talk to my daughter, she's 26 years old, right? What do you think she does? She immediately goes on to Google and says, how do I do it? And that's how they do it. And it's a whole different ballgame.
It is.
And so a corporation not following those standard SOPs, not that there's gonna be anything on the website reads, we can just go with this, what we've got here in the inserts and the packaging label, and we'll be fine.
Yeah, and I think that's where the law, at least now, is focused.
Judge, on one point, can we have Mr. Petrie's testimony, please? And again, Adrian Petrian, or Pepperman, I don't know if I'm pronouncing that right. He's the general manager in Romania. And so I asked him if there were any changes made to this thing. And he says just what I said, quote, and they've used this same manual since 2000 except for aesthetics. Yes, I think so, yes.
And yet, right on the instruction manual, the insert has a revised date, a revision date on this one of March 2021, because they're revised all the time to add things like, here's how you get a hold of people, here's the website, here's whatever else is going on, here's our certifications that have been updated. All of that gets added. Mr. Petrie does not speak English like you and I, Your Honor. He can get by a little bit. We had to translate it through this whole thing.
Judge, I can only go by testimony.
Yeah, but and here's the thing, and I just wanna reel everyone back in. I wanna look at this straightforward. Any warnings are limited to the packaging and the inserts. I mean, that's what it comes down to.
Okay.
And I understand you're taking a position, our packaging and inserts were sufficient. Yeah.
Judge, I mean,
So,
he said it twice. Okay, so the original language was prepared a long time ago, correct? Answer, you refer to the manual? Correct. Answer, yes. Question, yes. Answer, probably the manual was written when the design of this device was made. Question, in the 80s or 90s? Answer, yeah, I think so, yes. And that's page 152, 18 through 25. So I mean, the general manager told me twice that they didn't change this language.
And yet, he's not the person that wrote it because he speaks Romanian. So he doesn't know about any revisions. He's not the person who even said so. I didn't make it, I didn't draft it, I didn't do it. He knows nothing about this. So yeah, when it was probably first developed, that's probably true 35 years ago. But to suggest that he knows anything about the revisions to it up till now, he doesn't.
It's
And we're all gonna try to badger
Yeah.
someone into a corner. He'll be here to explain all this.
Yeah,
Jason Brown knows nothing about it, he's the general manager. This
Not
is
the
the general manager over in Romania. You know, no one knows anything about the product that I propose, so.
but I mean, the bottom line is this, and I think, let me see here. I'll grant, it is we're number 17, right? To preclude the meter defendants from arguing or inferring.
It's 16, Your Honor.
It's 6.
Sure.
That's why I'm asking.
Oh, no, 17.
17, right?
Yeah, I'm sorry, 17.
To preclude the meter defendants from arguing or inferring that that their failure to give warnings is excused by instructions or warnings on a completely different product and or on the internet. I'll grant that.
Doesn't say internet, but I get it, that's what we're expanding that out
Yeah.
to. That's okay, I get it.
But I mean, it was discussed. And the bottom line, yeah, I mean, I'm looking here,
I would have given the completely other product, okay? But what I'm worried about is that as I show these revisions that are done on these inserts over time, that would have been an insert that had a different revision when they first bought, let's say in 2015. And then they got another one next year and it was a 2016 revision. I should be able to show the changes that are made in the inserts over time.
If he's produced it in Discovery, Your Honor, and I haven't seen that, so if he's produced it in Discovery.
that's another issue. And the reason why I included the internet, because it was raised as an issue in the opposition. And then I look at argument, Holding and Allison versus Merck cannot be ignored because it predates the evolution of the internet. It's right there. That's all. So anyway,
We'll deal with it.
Judge, I think at Mr. Robbins' request, he didn't want to do 18 this afternoon. Tomorrow, I'm assuming we can do it. But I think, you know, if we have a couple minutes, maybe going through real water 1 through 14, we can clean up. I talked to Mr. Odou, and I think we have.
I'll step down.
No, I mean,
Oh.
with the court on the record. we can clean it up.
All right.
So one was, go ahead.
One's the motion to preclude admissibility of consent decree. The court's already ruled on that.
Is that your motion limiting number 4?
You know, I didn't have a chance to cross-reference one of the UNFW ones.
Yeah, so I think that's going to be granted, right?
Yeah, it was granted. It's motion limiting number 1 by UNFW.
Okay, so this one should be granted as well.
Okay, sorry, hang on.
2 is reptile, which we're agreeing to submit on the brief.
We will submit that on the briefs, Your Honor.
I'm sorry.
What does that even mean?
That's
It's
why
explained in the motion.
Well, the only reason I bring that up,
I think what happened is,
I see them all the time, guys. I
Yeah.
understand the purpose of it. And I'll just tell you, I mean, I can't, well, number one, motions in limine are to either pre-admit or exclude evidence. And as far as arguments are concerned by counsel, when it comes to closing arguments, I would hope, or throughout the course of the case, you follow Flick versus DeJesus and Leoshi, right? We know what arguments are appropriate, what aren't.
Right.
Bottom line, if improper arguments are made, maybe declare mistrial or do something like that. But I'm not really worried about that much in this case.
yeah, and where it came from though is Mr. Freeman, Rick Freeman, who's a good friend of mine, wrote a book called something about reptile. Now I think he's on version 3 now, reptile 2, reptile 3. So he's selling a lot of books, okay?
Yeah, no, I'm familiar with the book. But
Yeah.
my point is, where did this come from as a motion in limine?
Oh,
Because we're not talking about pre-admission of evidence or exclusion of evidence. We're talking about argument. And when it comes to those issues, those are Flick versus DeJesus, right? Leoshi. I think the late great Randy Maynard was in Flick versus DeJesus. Was that the one regarding the hot tub position?
Maynard,
Yeah,
you know, he must have practiced crying when he woke up in the morning, Your Honor.
right.
He could cry on demand.
He was a good lawyer.
He was a good lawyer.
Are we talking about UNFW's motion in limine number 1?
We're talking about real water motion moving number 2.
Oh. What about number 1?
Number 1 was granted when the court granted UNFW's motion limiting number 1.
So So number 2 is going to be denied the OG admission.
Yes.
Okay, 3, I think we wanted to argue this, so let's skip over to 4. So 4, Real Water had the same motion about this Burke article, so this should be denied.
Yeah, the Burke article's been pre-admitted, so motion, Real Water motion limiting number 4 should be denied.
Okay, 5, stuff that was covered.
Yeah, 5 is precluded testimony regarding other claims, lawsuits, settlements, or judgments. The court has ruled a great deal on that. I believe the questions remaining in their submission to the court relate to the testimony of Tom Pham and one other person, I'm drawing a blank. But this was part of the UNFW motion eliminating. See if I can pull that one out.
So this was part of my omnibus opposition.
You're talking about 4? Your water motion remaining.
Yeah, I'm trying to figure out which UNFW motion you've already argued that.
It was 10.
Yeah, that's it.
How could you forget?
I know.
Mhm.
Spent days.
Yeah, so I think Pam's the only one I'm aware of that's outstanding. Is there somebody else?
One other issue outstanding on that, but maybe not.
Okay, all right, so this should be denied except as to Pham pending the court's ruling on Pham, Your Honor.
Mix, put a little note by that. Which one are we at?
That was Real Water motion number 5.
And
Docket
what's the,
number 364.
364. You got that?
Yes.
And write it down, and you can write it down. Use that and highlight it, and there's a highlighter there, and you can just highlight it so as we go through it, we'll know.
6, I think should be argued. Real Water 7. Scientology, politics, I think we agreed to both of those points.
What was the agreement?
That was the agreement. The question was the only part of motion limiting number 7 was family squabbles. So it was testimony from Mr. Dosatel that there was arguments between Blaine Jones and Brent Jones. And we believe those are irrelevant because he couldn't tell us what the arguments were. He just was aware there were arguments.
Your Honor, I don't think I page lined that testimony. If you haven't looked at my page line yet, but I don't think I proposed that testimony. And I don't mind that being granted as that, Your Honor, even if we did page line.
Anything else, Mr. Odou, on that?
No, nothing else on that one, Your Honor.
So what's the
Uh,
Real water motion
Which one
limiting
is that?
number 7 is 366.
So that would be granted pursuant to the court's prior rulings.
Yes. Did you get that?
And then 8 is the Rocket Fuel one, so that should be denied.
That would be denied pursuant to the court's prior rulings. That's docket 367.
Yes.
9 there.
Real water mill number 9, which is docket 368. I think we were going to submit that on the briefs.
And we agree with that.
Okay, so we can write that, let's make a list of what's being submitted. Did you get that one?
I think that's the first one. And 10 we wanted to argue.
That's preclude pathology reports and results of non-clinics.
11 we want to argue. Correct. And then I have 12 being decided already, so that should be denied, right?
Yeah, so motion limiting number 12, which is docket 371, is to preclude other customer complaints and evidence predating the complaint pursuant to the court's ruling with some of the UNFW motions eliminating. I can find which one, but that would be denied.
Yeah, that would be 10.
10 again, yes.
Okay, and 13 should be the same, denied.
Yeah, docket 372 is pursued other customer complaints as hearsay. Again, that would be denied pursuant to the court's ruling
Okay.
on the UNFW motion that was similar.
And 14 was covered by the UN.
Docket 373, the court issued a minute order on the status of, immigration status of real water employees, and so
That's out.
Yeah, so that was granted,
Okay,
and that takes care of the real water ones.
so the ones we still have left on real water, we are summarizing again, would be, we have 3, 6, 9, which we're submitting over 10, 11, and that's it.
And so is that all the remaining real water?
That is all the real water motion to eliminate, Your Honor.
So after real water, we have,
After those, we have, I believe, a motion for summary judgment on superseding proximate cause by Milwaukee.
and then after that, how many more?
Okay, Judge, I have to.
Then we're not even getting close.
We're close, we're making good progress. This actually should speed up things.
We're halfway there.
I think we're over halfway. So Judge, tomorrow I thought we were gonna go back to UNFI, MSJ's, Belsky Haley, those two.
Agreed.
Although, those might be,
Now, we'll argue them and we'll proffer the evidence that supports.
All right, and then we have, Rich, is tomorrow.
Can we get numbers instead
That
of?
would be motion, Hanna motion with number 3.
Well, no, I think you're looking for the index number that we
You
have.
want the next number?
No, sir, just your MIL number.
You want this number? Or you want-
I personally just wanted the MIL number,
Okay.
like
That's,
Hanna number 5 or what have you.
okay, that's Hanna MIL number 3, which is 51 in our list. Hanna MIL number 4. And then after that, we have Tenor, which is plaintiff's motion to eliminate number 18. And I don't know, where were we at with that check?
I'd like to do that Friday if we could, please, Mr. Chairman,
Friday's fine with me.
if the court doesn't mind.
Okay,
Thank you, Your Honor.
and then 20 is Alcina, we're okay on that one? Come on.
Yeah, we can do it tomorrow.
Okay, and then we have,
I'm sorry, what number was doing it tomorrow?
I'll see it in them.
332.
plaintiff's motion to eliminate number 20.
Number 20, okay.
And then we have real water's motion for summary judgment on punitives.
Yep.
And then we have, motion on, real water motion limiting number 3. I don't think we're gonna get much further than that tomorrow, do you?
Now, the old ready, so,
Okay, I mean, yeah, I'm just saying, if you want me to roll tomorrow.
no, I think that's a good schedule.
It's good for the-
So I got one tomorrow, Hannah's number 3. Got it, and I think that one has to do with the CPA stuff, so I'm wondering when we're gonna do that, since I think there's several of us.
Which one are you talking about?
Number 3 is also one that you got with regard to.
I think we agreed there was no reason to do that until the court issued rulings on the punitive damages,
Damages.
summary judgments, and we,
So
perhaps
I'm-
even until we got to phase 2.
Yeah, I might be asking for that one to be filed until after, my opinion is here.
I think we already agreed to that, didn't we?
We did, so it's on the list right now, I get it, I'll be prepared, but I'm thinking we're trying to move that until I've completed this.
Okay.
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 115?
115, Your Honor.